Hello and hi everyone! In this video, we will cover the next subtopic, that is passing off or transfer of title. Transfer of property is known as passing off property. Property in goods means title or honor, and possession means physical possession. So the basic rule of transfer of title is that no one can give what he does not have. This rule is set in the magazine Nemo that quote non-habet, meaning no one can transfer a better title than he himself has. Thus, a person cannot give what he does not have, including he cannot transfer title that he does not have. For example, no one can sell the goods and give a good title if he is not the owner. Next, we will refer to Section 27 of SOGA in regards to this subject matter. Section 27 provides sale by person not the owner, where goods are sold by a person who is not the owner and who does not sell them with the owner's authorities or with the consent of the owner. The buyer does not acquire a better title to the goods than the seller had. So, Section 27 simply means if goods are bought from a person who is not the owner and without the owner's authority or permission, and the buyer is not aware that the seller does not have title, the buyer will also not acquire or get any title even he has paid for the goods. So, what is the purpose of the Nemo Dutch rule? The purpose of this rule is to protect the right of ownership so that when the good is stolen or sold without the owner's consent, the right of the owner is preserved. The Nemo Dutch rule is illustrated in the case of Lim Chui Lai and Zeno Limited. In this case, the company entered into agreement with contractor Ahmad to provide him with building materials for his culverts. Company bought the materials and delivered them to the construction site. Later, company came to know that Ahmad's contract was cancelled by the Petaling Jaya authority. Company informed Petaling Jaya authority that the materials on the site belonged to them. It was later discovered that Ahmad had sold the materials to Lim. It was held that Ahmad was not the owner of the materials at the time he sold them to Lim, as he had no title to the materials or authority to sell them. He could not give Lim any title. Nevertheless, there are exceptions to the Nemo Dutch rule. In cases where the buyer buys in good faith without notice that the seller is not the owner and he has paid a valuable consideration for goods, it is not fair to him when it is discovered that the seller does not have title. Thus, the law developed exceptions to this rule where, although the seller does not have title to the goods, the buyer can still get a good title provided he falls within the following 6 categories. First, estoppel. Section 27. What is estoppel? Estoppel may arise when the owner of the goods, by his conduct, make it appear to the buyer that the person who sells the good has his authority to sell and the buyer acts in reliance on it. The owner will be estopped or prevented from denying the seller's authority to sell. The buyer who takes the goods in good faith and for value will acquire a good title by estoppel. For example, Era tells Fazira in front of Sherry that Era wants to sell Sherry's bicycle to her, and Sherry nodded her head and keeps quiet. If Era sells the bicycle to Fazira, Sherry cannot complain that Era has sold her bicycle without her authority. Next, sale by mercantile agent. According to Section 27. Section 27 says that where a mercantile agent is, with the consent of the owner, in possession of the goods or of a document of titles to the goods, any sale made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by the owner of the goods to make the same, provided that the buyer acts in good faith and has not, at the time of the contract of sale, noticed that the seller has no authority to sell. Meaning, the owner of the goods, by his conduct, makes it appear to a buyer that the person who sells the goods for him has his authority to do so, and the buyer acts in reliance on it. The owner will later be stopped or prevented from denying the seller's authority. The buyer who takes in good faith and for value will acquire a good title by estoppel. So, who is a mercantile agent? A mercantile agent is defined in Section 2 as a person who represents the principal and having, in the customary course of business as agent, authority either to sell goods or to consign goods for the purpose of sale. For example, brokers, auctioneers, and second-hand car dealers. So, what happens if agent sells owner's goods without owner's authority to sell? Buyer can still obtain good title as long as the following requirements in Section 27 are satisfied. A. At the time of disposition, the mercantile agent must be in possession of the goods or the document of title to the goods. B. Possession of the goods must be with the consent of the owner. C. The sale must be made when acting in the ordinary course of business of a mercantile agent. That is, sale was done within business hours at a proper place of business or in any ordinary way in which a mercantile agent would act. And D. The buyer must have acted in good faith and at the time of contract of sale must not have noticed of the agent's lack of authority to sell. Meaning, the buyer honestly does not know that mercantile agent has no authority to sell. Third, Section 28, sale by one of joint owner. Conditions in Section 28 to fulfill are: A. The goods are owned by several persons jointly, and B. One of the joint owner has sole possession of the goods with the consent of the co-owners, and C. The buyer buys in good faith and does not know at the time of the contract of sale that the seller has no authority to sell. For instance, Alice and Bibi jointly bought a car. Both have equal share in the car. The car is in Alice's possession with Bibi's consent. Alice sells the car to Keith. Bibi did not agree to the sale and had not given permission for Alice to sell. Keith has title as she bought it from Alice, who is a joint owner, provided Keith bought in good faith and without notice that Bibi did not authorize Alice to sell. Bibi will have to sue Alice. Next, Section 29, sale under avoidable contract. Section 29 states that where the seller had obtained possession of goods under avoidable contract under Section 19 or Section 20 Contracts Act 1950, but the contract has not been rescinded at the time of the sale by the rightful owner, the buyer obtains a good title provided he bought in good faith and without notice of the seller's defect of title. What is a sale under avoidable contract? A sale under avoidable contract is caused by coercion, fraud, undue influence, or misrepresentation under Section 19 and Section 20 of Contracts Act. For example, in a situation, C, either by coercion or undue influence, give possession of his car to A. A sells to B. At the time of the sale, C has not rescinded the transaction. B gets a good title to the car provided he buys in good faith and has no knowledge that A had used coercion or undue influence to obtain possession of the car from C. However, if at the time B bought the car from A, C had already rescinded the transaction, B will not get title. Next, Section 30, Subsection 1. sale by seller in possession of goods after sale. Accordingly, seller having sold the goods to the buyer continues to be in possession of the goods or document of title to the goods. The seller or mercantile agent acting for him then sells or transfer the goods or title to another buyer. The new buyer takes in good faith and without notice of previous sale. Here, one seller sells the same thing to two buyers. The seller sold the goods to the first buyer, title to the goods has passed to the first buyer, but the seller is still in possession of that goods or the documents of title to the goods. Finally, Section 30, Subsection 2, Sale by Buyer in Possession. Section 30, Subsection 2 provides, buyer sells to another buyer. Buyer having bought or agreed to buy goods obtains possession of goods or document of title with consent of the seller. The buyer or his mercantile agent acting for him sells or transfers the good or title to a subsequent buyer who buys in good faith and without notice of the original seller's right to the goods. The subsequent buyer obtains a good title. In the above situation, a buyer buys goods, obtains possession of the goods or documents of title with the consent of the seller. He can pass a good title to an innocent second buyer, even though he may not have title yet, or the good title remain the seller. In the case of Newtons of Wembley Limited and Williams, and sold a car to L, who paid by check. There was an agreement that title would only pass to L when the check is cleared, and allowed L possession of the car. The check was dishonored and rescinded the transaction. In the meantime, L sold the car to M, who bought it without knowledge of this fact. Then, M sold it to the defendant W. In this case, it was held by the court that L, the first buyer, was in possession of the car with N's consent, thus he could pass the title to M, who in turn could pass title to W. So I hope that this video will help you to understand on passing off or transfer of title. Till next video.